May I begin by just stating that these opinions that I have are mine personally, and I don't intend to advocate for either the Sindh High Court or for any other member of the judiciary when I make these statements. I've been a judge for just about a year. Prior to that, I was a practicing lawyer. And my understanding of an approach and perspective of how the system absorbs arbitration is not too good, I must admit. Let's just look at it in perspective of what Mr. Ahmed Bilal Sufi said, and I can't agree with him more. The purpose of a court should be to enforce a contract. That is potentially the most important thing that a court can do in terms of contractual obligations. The system that we currently have and our procedure doesn't encourage that. What it does instead is permits a person to enter into a court and delay the process for the enforcement of an obligation. And it does that both in terms of contracts, and it does that both in terms of arbitration awards. On a very practical note, when I was sitting on the original side of the High Court of Sindh, when it came to enforcement of arbitration awards and our cause lists, they are literally last on the list. So after a day of 50 cases, they come up right at the end when there's very little time to actually hear the case for that enforcement. And this is just one aspect of how we can just change that to bring it to the front to allow for the enforcement of such awards. The other aspect that I've found quite often is that an arbitration proceeding has started, and instead of allowing that arbitration proceeding to proceed, we find ourselves with multiple litigations which are attempting to frustrate that process. And that is potentially one of the biggest distractors from the enforcement of arbitration awards, which really needs to be procedurally addressed in our systems. Added to that, and I know Mr. Mia Hassan Gul Aurangzeb is here, we have also multiple jurisdictions. So we have not only the original civil jurisdiction, we have the constitutional jurisdiction. And you will often find that constitutional petitions are filed to invoke that jurisdiction, again to frustrate arbitration proceedings. And I refer to Mia Hassan Gul Aurangzeb because he advocated twice and he threw those cases out. But that process took time. So when we choose an arbitration process, are we able to turn around and guarantee that that arbitration process will be the only process that is followed and which then comes into our legal system for enforcement and which is then enforced expeditiously? And to be able to achieve that, you need to turn around and bring clarity to the use of those other jurisdictions to bypass the arbitration process, which currently I think has not particularly been done. I mean, take for example the the Supreme Court of Pakistan. It has an original jurisdiction, and it can turn around and invoke that jurisdiction to bypass an entire arbitration proceeding. So there are multiple forums that can be used to turn around and get away from just allowing that arbitration process to continue. And unfortunately, we need to bring clarity either in the law, in our procedure, to say, look, if you have an arbitration, do that, come for enforcement. I think it was earlier stated that the two grounds would be jurisdiction and natural justice. I think that's good enough. Well, I don't think that there are any real issues with ICC. The problems that we have in terms of enforcement of any award is really one of time. That's probably the biggest issue, and that's a systemic issue that exists in the legal system, which can be addressed. After the New York Convention was ratified in 2011, we took some time to develop the paradigms on the basis of which such awards would be enforced. But with the recent judgment of Justice Mansoor Ali Shah, I think that is now more or less settled. So it really does not require much dispute now as to the manner in which those awards will be enforced. The problems, as I earlier advanced, were really in terms of the time period to get it in there. And that is something that can be easily addressed by turning around and by doing a bit of case management on those. If you just do a bit of case management, those can get some priority, they can be enforced. And the other issue, of course, as I earlier mentioned, was in terms of the multiple jurisdiction issues. In terms of the New York Convention, and now with the Arbitration Act of 2024, which is being processed right now through Parliament, I do believe that that will really cut down a lot on the bottlenecks that existed in terms of enforcement of such awards. I think that the framework that you're actually developing in terms of ICC arbitrations is important. I think the biggest issues that people in Pakistan or companies in Pakistan, I think it was earlier advocated in the construction zone as well, is that we have a take it or leave it option. And I think that's probably one of the biggest issues that ICC could possibly address in terms of bringing some parity. Because let's be very honest, some of these people don't want to dispute. They actually want to complete their obligations, but are being burdened with certain obligations at time which they feel they have no opportunity to do anything else but to accept. So in terms of the ICC, if that was something that could be addressed in terms of the bargaining power, in terms of contracts, that might be something that needs to be looked at.